Now call the case of State of Kansas versus John Ewing, case number 128942. Counsel, you may approach. And Mr. Meharry, when you're settled in, you may begin your argument.
May it please the court, Peter Meharry. I'm here for John Ewing. I deserve 3 minutes of my time for rebuttal.
Noted. Thank you.
Thank you. In this case, Mr. Ewing was convicted of multiple offenses, the most severe being a felony murder charge, along with an aggravated kidnapping charge. And those charges, we believe, cannot stand on appeal. And I'd like to start with the third issue in the brief, and that deals with the sufficiency of the evidence for those charges. The felony murder was based upon the charge of aggravated kidnapping. However, there was no taking or confinement sufficient to support the charge of aggravated kidnapping in this case.
I assume you've watched the video.
I have watched the video, Your Honor.
Yeah, and so tell me why that there's not sufficient evidence of a taking, of a confining, of a dragging, of whatever occurred during that extended period of time. It wasn't just like an instantaneous kind of action. It took a little while for Mr. Ewing to get the victim to where he wanted her to be.
The problem is when you watch the video, and the video was played before the jury, it's certainly in the record on appeal.
Certainly that's not the only evidence. There's other testimony, but the video itself,
But what the video shows is that my client comes up behind his on-again, off-again girlfriend and assaults her. He starts battering her. He starts grabbing her. He starts pulling her, dragging her.
She's in the car.
She's in the car doing something with the car. He pulls her out. But when you look at the kidnapping statute, it's just not covering every confinement, every taking. There must be some legal significance. The statute says kidnapping is taking or confining any person by force, threat, or deception with the intent to hold that person to do certain things. In this case, the state used two subsections: to facilitate a crime, or to inflict bodily harm, or to terrorize. He's not taking her to do those things. He's already doing those things. The bodily harm, the committing the crime, that is inherent and part and parcel of the assault. It does not have any independent significance. And I would point this court back to State v. Buggs, which is now 50 years old. In that case, the facts were that the owner and her son of the Dairy Queen were locking up, closing down, walked outside into the parking lot. It was there that they were approached by two individuals, one being the defendant. He forced them back into the Dairy Queen. So that taking into confinement was important because he forced them back inside so that he could rob them and also rape one of the victims. The taking or confining in that case allowed these other things to happen. The taking or confining here was just when he was battering her. It did not allow that. It did not facilitate the commission of the crime. It was just part and parcel of that assault. So there's no legal significance to that taking or confining. And aside from the Buggs example, two people in a bar exchange words, one grabs the other and punches them. There is some taking or confining there, but that's not an egg kidnapping. It has to have some significance. The statute doesn't say kidnapping is taking or confining any person, period. It's to do so with the intent to hold that person, to facilitate a crime, or to inflict bodily harm. And here that was happening before
He did take her, drag her, beat her, and then drag her to the home, and then kill her. Why isn't that facilitating the murder?
The murder, as far as her being killed, I don't think you can say it took place after she got to the trailer. The murder was an ongoing, essentially, assault, the result of an ongoing assault. And that started right when he came up behind her when she was in her car. Again, I don't think the taking or confining had any independent significance. It did not facilitate anything, did not allow him to do any of the things that were required under that statute. So that's why we don't believe that there is sufficient evidence for the aggravated kidnapping. And then as well, because the felony murder was based upon that, that would fall as well.
Does our burden decision have any role to play on the A3?
And certainly, Your Honor, I recognize Burden has said that essentially what Buggs talked about does not apply to subsection A3. I believe that Burden was incorrectly decided, and I've asked this court to overrule it because the limitations within the statute, those limitations that Buggs talked about, are just as applied to subsection.
We would have to reverse it to adopt your sufficiency argument.
That is correct, because this court has said in Burden that doesn't matter. Any taking or confining is sufficient. But I think that what the problem with that, and I think what Buggs kind of recognized, is that collapses everything down into a kidnapping. My example about a car theft. Any battery can be bumped up to a kidnapping. Any assault will be a kidnapping. Any sex crime will be a kidnapping. The legislature has gone through the criminal code and said these crimes have these severity levels. Aggravated assault's a 7, robbery's a 5. They've gone through all of this and said, this is what their severity level is, and that corresponds to what we believe is an appropriate sentence. But if everything can be a kidnapping, that's thrown out the window. If every rape can be a kidnapping, what the legislature said as far as an appropriate sentence for a rape is now double. You're looking at 2 severity level 1 offenses. The legislature knew that these forcible crimes had inherent in them some level of taking or confining. But they still said, hey, you know what? A battery can be a misdemeanor, it can be up to a 4, anything in between. It said a robbery is a 5. And that's why I think Burden is wrong in that it ignores that. It erases those distinctions that the legislature did make because it collapses everything again down into a kidnapping. An appropriate reading of the statute, the statutory language, is what Buggs talked about. It has to have some independent significance for it to be a kidnapping. Without more, it is not, and that's why we believe that here, this was an assault. Any taking or confining was just part and parcel of that assault. Look, I recognize the video. It's a terrible video. There's no way around it. But that still doesn't change the fact that the taking or confining was just part of that assault. He didn't take her to inflict bodily harm. He was already doing that. So we believe the evidence was insufficient for that charge as well as the felony murder on which it was based. And we believe this court should vacate those convictions. I did want to touch quickly on the second issue in the brief, which deals with the district court's failure to give the proximate cause instruction. The district court did give the lesser included offenses of reckless second and involuntary reckless. The state charged this as felony murder in the alternative premeditated. So as part of the lesser degree chain for premeditated, it did instruct on in reckless second and involuntary reckless. At trial, defense counsel asked for approximate cause instruction. Specifically, he wanted additional language. The fault or lack of fault of Stevens is a circumstance along with other evidence to determine whether the defendant's conduct was or was not the direct cause of her death. The district court refused to give it because it did not believe that there was evidence presented that unequivocally stated there was another cause of death. And I think the first problem with what the district court did is that it did not look at it in the light most favorable to that instruction, to the requested instruction. I think the district court just looked at the evidence and said, I don't think it applies. The standard is whether or not there is some evidence to support the instruction. And here there was conflicting evidence on the cause of death. There was evidence of contributing factors, namely the victim's methamphetamine use. And when you have those questions swirling about, it's important the district court properly instruct the jury, give them a proper legal framework so they can evaluate whether or not my client was truly the direct cause of her death.
The state makes the point in their brief that if we affirm on the felony murder conviction, we need not reach the proximate cause issue. Do you agree with that?
I do agree with that. The way it worked out, he was convicted of reckless second and felony murder because they merged, that he was sentenced under the felony murder. And as it stands now, essentially there is no conviction for reckless second. But as I've argued that felony murder should be vacated, then it would fall to the reckless second. And that requires the jury find he was the direct cause of her death. And that's why I think this court should reach this and needs to, because as I said, there's some question about the cause of death in this case. And the instruction given was the standard pick. And I recognize that there is case law out there that says the pick instruction establishes causation. But I don't think it's that simple. Just saying defendant killed the victim doesn't instruct the jury that he has to be the direct cause. It doesn't instruct the jury how it should consider contributing factors. And we do have those here, and we do have questions on cause of death. So a full instruction that he has to be the direct cause of death was necessary. And given that that was a key part of his defense, it can't be viewed as harmless. The jury needed that legal framework to evaluate his defense. He argued he wasn't the direct cause. He had expert testimony to that effect. So we believe that it should be reversed for those reasons. If there are no other questions, again, we would ask this court to vacate his convictions for aggravated kidnapping and felony murder and reverse for the other reasons stated in the brief.
Thank you.
Thank you.
May it please the court, Jody Litvin on behalf of the state. I will go ahead and start in the same order with issue 3. There are multiple ways that the state has briefed this, but our position is that here, because there was 2 subsections that we charged and the jury was instructed on for the aggravated kidnapping. One, burden controls one of those, and so this court would have to overrule burden in order to get out of that aggravated kidnapping conviction. That's for A2 or whatever subsection that is for the burden. For bugs, our first position is that because this court has indicated a willingness to overturn bugs, the test in bugs should be abandoned. And this case is different than in Couch and in Butler, because here the state has briefed it and has asked this court, it's brought directly to the court to consider essentially abandoning that test from bugs. So we would ask this court to consider abandoning that test. And for the same reasons that are listed in the dissent and concurrence in Couch and Butler, that members of this court have said, it's really a multiplicity issue. So that we have a test for that, we can determine that, and that's the more appropriate analysis would be a multiplicity analysis and not this bugs test. So that's our first argument here. And secondarily to that, it shouldn't be extended to burden because again, members of this court has not considered a willingness to overrule burden. So we think the test in bugs should be abandoned. It shouldn't be extended in any manner. And we're directly asking for that in this case, whereas it hasn't been done before. If this court determines that the bugs test should be upheld, our second position is that under this 3-part bugs test that the state did present sufficient evidence of aggravated kidnapping here. We would disagree that this was slight inconsequential or incidental confinement, that the confinement was just inherent in the nature of the murder, and that the confinement didn't make the commission of the murder substantially easier or substantially lessen the risk of detection. And that's kind of the three-part test in bugs. The evidence here, as we've noted, it's all on video. It's a very brutal beating. Starts in the driveway, and just to put it in context, there was evidence that the defendant had deflated the air in her tires just to get the victim out into her car in the first place in order to sneak up on her, which he did. So we have him on video deflating the air of the tires. And then when she comes out, which he said, well, the compressor will wake me up so I can find her and attack her then. And that's essentially what he did. She was fixing her car. He came up behind her, began this brutal attack. And I don't know that I have minutes, but there's at least 2 minutes where he's dragging her by the hair from the car, continuing to brutally beat her up to the stairs of the trailer, pushing her through the door. She's continuing to resist and fight back this entire time. And our position would be that he did this in order to make the attack easier, make the murder easier, and to lessen the possibility of detection. So this wasn't merely incidental to facilitate the murder. He could have continued to beat her and murder her right there in the driveway, and anybody could have seen. But by taking her inside, of course, it gets her out of the public eye. He's able to do that easier. She can't escape as easy when she's inside, of course, or call for help or otherwise attract attention to her. So for those reasons, we would ask this court to affirm the aggravated conviction, kidnapping conviction if the bugs test remains. I think that's all the points I have on at least the sufficiency of the evidence for that. And of course, if there's sufficient evidence to support the kidnapping, then the felony murder is also supported. And then just some brief comments on the second issue for the proximate cause instruction. The state's position here is that the district court got it right when it found that it was not legally or factually appropriate to give this instruction. I'm not sure it even applies for these two crimes because I think the case law is really an involuntary manslaughter for a DUI is where it has been held to apply. So our position is that the elements, language, and the elements in both of the crimes for reckless second-degree murder and involuntary manslaughter do cover this proximate cause instruction. Of course, this isn't a PIC instruction, so it's not a standard one to give anyway. But it's not legally appropriate because it is already covered in the elements instructions for those two crimes. And as far as factual appropriateness goes, the district court held that there really wasn't evidence of this, I'm not sure the term for it, secondary. Well, there was evidence for a contributory cause of death, but the main cause of death was the loss of blood and the blunt traumatic injury / loss of blood and internal bleeding. Methamphetamine intoxication was the contributory cause of death, but it wasn't the primary cause of death. And even the defendant's own forensic pathologist who testified agreed with those findings. So unlike the cases I think that we've compared it to, there wasn't a completely separate cause of death that was testified to by an expert. We just don't have that here. Even his expert agreed that methamphetamine was just a contributory cause of death and not the primary cause of death. So without that, we don't believe it's factually appropriate either. And we believe the court found correctly that it wasn't legally or factually appropriate to give and should not have been given. Unless this court has any further questions, I can hit on the first issue about the prosecutorial error. Our position is that the prosecutor here did not improperly discourage the jurors from answering questions honestly or participating in the voir dire process. The defendant's argument here is that comments about participating essentially in the process and being open and honest were inappropriate to say to the potential jurors. And our position is that this is not inappropriate to say to potential jurors. And it's a really fair and correct statement of what the process is and kind of a
probably, I don't know, it skirts, doesn't it trivialize what the significance of even what the district court tried to communicate to the jury in the outset was this is important. It's important public service. It's what differentiates our criminal justice system from others in the entire world. And then you get up prosecutor gets up, I know you don't want to serve, but by being candid, it just seems to me it doesn't place the significance of what he is doing in voir dire to try to get fair and impartial jurors, and says, I know there's a lot of you who want to get out of this, and the best way to do it is to be candid. That was my concern, is like, what is he doing making that kind of statement?
Well, and I will tell you, I did speak to the prosecutor, and he does say that this is he gets a chuckle every time. I mean, I think everybody in the room understands that this is a lighthearted sort of comment, but I disagree. I think it does get exactly to what the process is and gives the jurors the,
You do? Be candid so you can get out of this?
be candid and give us honest and open answers so we can determine who needs to sit and who
Yeah,
doesn't.
okay.
I mean,
It's, anyway, I go.
I just-
think I've made my point.
yes, I can see how you would.
Trivialize what we're all here for.
Yes, and I can see how the opposite, I understand the argument that, well, the opposite is true then. Don't be honest and open and you will get to serve. That was the purpose of this whole argument. It wasn't to show that his comments weren't like a proper assessment of what jury selection is. I think it's taken out of, it's overread to say that if you're quiet and don't say anything, then you can stay on the jury, which is really more their argument, at least the way that I read the issue was framed here. So I think the process is participation is important, answering questions is important, and the more information they know, the better determination they can make about who needs to sit on the jury. And I will point out that the defense counsel didn't do anything to otherwise rephrase this or challenge this. And in fact, the defense counsel said, if you guys participate and volunteer, that helps. It really helps us out. We want to have a fair trial for both sides. So I think the sentiment was the more participation, the more we're talking, the more that we're answering questions, the better we can determine who needs to sit on this jury. Again, if this court finds that this was error, we would argue alternatively that this is harmless error. For the reasons that I set out in the brief, although an objection isn't required, there was not one here and that can be taken into consideration. And there was no evidence from the actual jurors who served on the jury to suggest that they themselves would be anything other than fair and impartial. And I had a bunch of record cites to all of the jurors who actually served on the jury to show that they would be nothing other than fair and impartial in their answers. And then secondarily, the strength of the evidence, which again, we've talked about the video, it's a brutal beating. There's overwhelming evidence here of the crimes. Unless this court has any other questions, I'll stand on the remainder of the issues on my brief.
Any questions, Colin? Thank you.
Thank you.
Unless this court has questions, I would waive rebuttal, Your Honor.
Any other questions, Collins? Thank you,
Thank
Mr.
you.
Mahari.